Good afternoon, everybody, and welcome to Law 2022 Online, Civil Litigation Spring Shape the Debate with myself, Claire, Helen Swaffield, and Andrew McLaughlin. In this live session, you can put questions to our experts, Helen and Andrew, and interact with the information as being delivered. Today's live Q&A is due to last approximately an hour, and we'll cover pre-submitted questions and live questions. To the right-hand side of the chat function, all questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitor group for more information. And a recording of today's live session will be available on the website in the next few days. Okay, so we'll introduce our experts. Helen is barrister and head of contract law chambers. Helen's been a barrister for over 20 years and has worked in London and internationally before starting contract law chambers at Chancery Lane. Currently, she's involved in large multi-party cases involving hundreds of claimants in the High Court. She's given seminars on contract and commercial subjects and litigation. And as part of the Law 2022 Online, Helen's sessions include CPR 36 and updates and civil litigation updates. And Andrew is a solicitor who has high rights of audience for civil and criminal proceedings and sits as a recorder in the Crown and County Courts. He was appointed as a court examiner by the Lord Chancellor. His wide-ranging experience and practice, coupled with ongoing training from the Judicial College, gives Andrew a unique insight into judicial thinking and therefore what you should be doing. His main areas of specialism include civil and commercial litigation, as well as all types of personal injury, from road traffic through to industrial disease and clinical negligence. And as part of Andrew's Law 2022 Online sessions is cost and case management and procedure in practice. Okay, thank you very much for the introductions, everybody. And so we'll start to commence with the pre-submitted questions that we've received. So firstly, Andrew, it's to yourself. Have the courts provided examples of what constitutes a significant development after a budget has been approved?
Okay, yeah, thank you very much for that question. Regrettably, the answer is no. The courts are very loath to give specific examples, if you like, almost provide practitioners with an encyclopedia of what constitutes a significant development. So it would really be helpful if they did, but they don't. And the reason why no examples are given that people can work from is that there is a requirement with regard to significant developments to have a look at the fact sensitivity of what may constitute a significant development. In the presentation that and the notes that accompany it, we've looked at 2 or 3 cases, and the common themes coming out of those cases are that the High Court circuit judges dealing with High Court matters are saying, no, we're not prepared to give examples of what constitutes a significant development. The vast bulk of the decided cases have said that the applications to say there have been significant developments have been turned down, and that included in one case the doubling of the value of the claim. So I mean, that was, I suppose, quite on the face of it, quite an unusual, you'd think, decision. But the reasoning behind it was that the judge said the parties should have been aware at the time they were preparing the budget that the value of the claim could actually double in value. Similarly, with regard to disclosure, where you would think, well, actually, we have now become the subject of disclosure that we didn't anticipate receiving. So, for instance, receiving thousands and thousands of documents in various forms that weren't anticipated. Again, the court has said this should have been anticipated when the parties were setting about their budgets. I think the learning point coming from all these cases is, in fact, fundamentally the need to really spend proper time crafting the budget. Don't just prepare these budgets on the basis of, some sort of autopilot route towards cost budgeting in the hope that somehow it'll all sort itself out later on. I think that the requirements are quite strict in terms of getting it right, and you're in the best placed position to get it right going into the costs and case management. And that doesn't mean just the cost side of things, but actually the court orders and the case management of the matter that tends to impact on the costs of the case. So as I say, regrettably, no specific examples given. It's all down to fact sensitivity. So thank you for that question.
Okay, just leading on from that, we've just had a live question come through, and that's just asked, please could you give the name and citation for that case where a doubling of the value is not a significant development, please?
Yeah, the case was actually called Churchill versus Boot, and it's actually in the notes that accompany this sort of live session. So that was Churchill. I think it's Mr. Justice Picken was the High Court judge in that case who gave that. What I would be anxious for people though to note is that the fact sensitivity of these decisions. I should make it clear that in a particular case, doubling the value of a claim may well be considered a significant development because it's out with the thinking of the parties. But in this particular case, it wasn't said to be so. So I hope that answers that supplemental point. Thank you.
Thank you. And then to yourself, Helen, how do I vary a cost budget? Oh, you.
I put myself on mute there. Yeah, sure, that's okay. Interestingly, I think Andrew and I have happened upon the same subject, which is kind of good, isn't it? And of course, this is the new Precedent Tea that's in use. And really picking up what Andrew said, I mean, it's very difficult to know, no guidance at all. We have got now the Excel for Precedent Tea. And I was involved in a case where we were changing some pleadings, the usual. And of course, right, well, we have to serve a Precedent Tea. No, we'll just, you haven't pleaded to it, so it doesn't actually change your pleading. I'm just changing the figure in mine, or you have pleaded to it. It doesn't, change it. You've denied it, so fine. You're not going to change your sentence, so I'm not paying you any money to vary your pleading. Oh, well, no, if you change your figure, we're going to have Precedent Tea. And it just seemed sort of a sledgehammer to crack a nut, really. And I think the problem with these serving a Precedent Tea, which is the mechanism by which you change the budget, you then have to go to the court with your begging bowl and say, please, can I have a newly approved Precedent Tea, which sort of intersects and revises the budget. To do that, you've got to have something, significant, as Andrew was saying, much more significant than changing the figure in a pleaded schedule of loss. But it is now in circulation. If you haven't seen it, then you can find it on the usual websites for the CPR, and if you sort of look at Precedent H, you should find a tab there, or just Google Precedent Tea. And be aware that if you are making changes to the budget, you have to use that form to do it. But this is the same debate, I think, as independent costs orders, which sit alongside the budget. So, you've got a budget and then somebody makes an application which wasn't thought of for, specific disclosure or whatever. And you think, oh, gosh, we need that. We didn't see it at the time. It's not a hanging offence. We'll make the application and get an independent costs order for that application, which is carved out of in addition to the budget. So, whether or not you need Precedent Tea for those sorts of situations where either it's just de minimis or you can get an independent costs order, that's debatable. But if you do need to have a sort of root and branch wholesale change or some more significant impact, and that's the new form to do it.
Okay, thank you very much for that. And then Andrew, back to yourself. Sticking with budgeting, what assumptions shall I always make when cost budgeting? Oh, sorry, you are on mute as well.
We're being very deferential to each other by muting. Yeah, okay. The answer to this is you shouldn't make any assumptions as it were as a repeat nature. It's preparing a budget is not sort of autopilot approach. It's got to be specific to the particular case. Anecdotally, and we're talking maybe 2 or 3 years ago now, judges were complaining, as I say, you know, off the record, so to speak. Got to be careful what I say. But as a general proposition, they were faced with precedent H's where there were pages and pages of assumptions. And don't forget the judge has got to read through these as part of any preparatory work, which is another difficulty. Sometimes listings officers weren't giving judges the appropriate preparation time to read these, and therefore you can imagine the frustration of receiving, you know, 4 or 5 A4 sides of assumptions. And many judges would say, well, actually, they weren't relevant at all to what this case was about. It's almost as if, no disrespect to a cost drafts person, but a cost drafts person was just simply putting in 4 or 5 pages. As you can appreciate now, Precedent H itself has changed in that the assumptions have to be contained within a particular phase. So it's a little more difficult to make, as it were, generalised assumptions, given the format of Precedent H, because the assumptions have to be under the particular phase. Therefore, don't always make any particular assumptions. Craft your budget and the assumptions, therefore the assumptions, towards the nature of the case. Again, it's difficult to give examples that are going to be particularly pertinent, but you know, in relation to disclosure, if you because you can envisage a case by way of example where the parties see the case slightly differently, that one party thinks certain issues are not relevant at all, whereas another party thinks those particular issues are very relevant and pertinent. The difficulty is, how do you accommodate the approach that's going to probably be adopted by your opponent in that case? You've got an inkling of it, and therefore probably make an assumption in that case could be that you will cost your disclosure phase of a budget on the basis that you'll only be dealing with these particular issues, and that probably is a sensible reaction to what can be a particular problem going forward when the disclosure from your opponent includes lots of material that you consider irrelevant, but because you're now lumbered with it, so to speak, subjectively, you're going to have to probably do the decent thing for the client and look at it. That of course, could set up an application, as Helen's referenced, for a Precedent Tea to amend the budget when you get copious amounts of documents that you didn't think are relevant, weren't anticipating receiving, but in fact the opponent is persisting with that particular approach. So as I say, in summary, I think it's fundamentally incorrect to make assumptions in each and every case. Try and be, you know, in terms of your preparation, focus in on what you can perceive to be, you know, the proper issues going forward in the case. Thank you. Thanks.
Thank you very much for that. And then Helen, back to yourself. How does the court sanction conduct issues?
Well, this is really picking up again with costs, and the interesting thing I think that's happening now is that we see the way in which these the percentages of costs which are proportionate or issues-based. We don't get a lot of issues-based costs orders, but proportionate costs orders are just all the rage. You know, they're really in the wind. And I picked out the European Real Debt Fund Cayman and Trion case, which, you know, was was a case where you're going to win, great. So you sort of stand up hopeful that you're going to get your costs, not necessarily on an indemnity basis. That wasn't a Part 36 event, but just that you've won, you know, and then you sort of see it disappearing away from you. And the problem is that in that case, the court reflected the serious misconduct of the defendants, and that made a substantial reduction from the costs that they would have otherwise received. And so they had also sort of put in too many things. They'd overloaded their defence. And, you know, there's no shame in that in many ways, but you do have to think about what you can actually get home on. So they didn't win on everything. And there were some serious conduct issues. And of course, what we're talking about with serious conduct issues are things like the lies that were evident when giving evidence. I'm not sure it means, you know, oh, I put too much in the defence. It's really the court disapproving of the witnesses because their witness statements and their testimony is found to be inaccurate. Anyway, long story short, they're going to win. They have won. They're going to get their costs. And eventually, the court puts into the mix 10 points. And the 5 points are with them, one of which is that you've won, you know, that you've taken some money off the other side. And the other point is that you've overloaded your defense. And then the other point is that you've lied in giving evidence. And then there's another point. And then there's a further 5 points that are in relation to the claimant. And it sort of stirs the pot with these points that are relevant to the outcome, to the conduct. And as we know from CPR 44, all the circumstances of the case, they result in a score draw, no order for costs. And I really like that approach. It's an approach that I found to be successful when you are, for example, you have an application, and you might have an application for, say, abuse of process, or, you know, security for costs, or specific discretion. You put them together in one N244, and you get one and you lose the other. And the other side is saying, well, you know, you should be paying our costs. And actually, those score draws are really handy, and they may not, you know, give you your costs, obviously, but what they do is they protect the party from having to pay those costs. But I think a great disappointment, really, to the defendant in that case, because, you know, the dim view that was taken of the witnesses' evidence resulted in a score draw. So this kind of balancing act, this is why it's so fascinating, isn't it? When you kind of have to really think this through when you embark upon both setting out your statements of case, you get home on what you can get home on, you know, you plead what you can get home on, and also your strategy in relation to interim applications, because obviously they can be quite expensive, and if you're acting for somebody who doesn't have insurance, and you might just want to keep your head down, get them to trial, don't try anything too fancy. But this marriage of, say, an application where you think, well, they're definitely wrong on that, I can put that application in, and I can try this one, which may be a little bit more uncertain in its outcome. But then if we get one and we lose the other, we can always go back to a score draw, and we can get no order for costs. And I had one which was a summary judgment, and there were two different parts of the case, and they won one and we won one. And it you know, they wanted this 80% of this, and they'd carved up all the percentages in sort of a bewildering and confusing way. And in the end, I just said, look, there's no order for costs. When you take the balancing factors, you boil it all down, it's a score draw. That's it. They've won one, we've won one. And that's a very handy approach. And I've seen that score draw approach now coming up more and more, where the court says, oh, really? You just won as bad as bang your heads together. Nobody gets anything. That's it. Goodbye. You know, and it's you can work with that a little bit when you're sort of planning your interim application strategy. So, yeah. Anyway, there we go.
Brilliant, thank you. And the next question, back to yourself, Andrew. Is it better to apply to amend a budget rather than to seek to justify an increase in costs by using the good reason exemption?
Thank you for that. Yeah, and the answer is yes, it is. As you know, Helen's already mentioned in our session today, Precedent Tea is there for a purpose. It's specifically part of the civil procedure rules to get people promptly, and that's something I don't think we've emphasised today, promptly to apply when they feel that there's been a significant development in the case, and promptly is interpreted as being the equivalent of an application to set judgment aside. It's got to be done within a pretty contemporaneous time frame. The reasoning behind it is, of course, to allow the court to continue to cost manage a case, and therefore, yes, if you feel there's been a significant development, i.e. something completely out with anybody's reasonable thought processes. I know we've touched upon Churchill and Boot. That I know somebody had asked what are the specific references. It's 2016 EWHC 1322, because I just mentioned the name of the case, but that's the citation for it. Assuming there is something novel out with the contemplation of the parties, the approach has got to be to amend the budget, because there has been a significant development, because at least the court can look at this. You might not get all you're looking for if you do apply to amend the budget on the basis of a significant development, but you may get something. What the courts, I think, are alive to, which I'm not saying anybody on this session will do, but seek to apply to amend a budget because of a purported significant development, with a view to clawing back costs that have not been allowed on the face of it when they've actually gone to a cost and case management hearing to start with. And again, there's a couple of decisions where the courts have said, actually, this is a second bite at the cherry, and we're not going to allow it. This was within the contemplation of the parties at the time, and we won't allow it. The corollary of that is if you sort of say, well, I'm not going to apply to amendment budget because I'm a little bit concerned as to whether a court will say it's a significant development. I'll rely on the good reason exception at the end of the case. The problem you've got with that approach is that you're asking the court, the burden's on you to show that actually there was a good reason to depart from the budget. And you can see maybe a series of cases where the courts are going to say, well, you rather than come to us now at the end of the case, having won it, you're now trying to exceed the budgets as approved on various phases. Why didn't you apply to show a significant development contemporaneously? That's what it's there for. And as I say, the burden on the receiving party to show good reason can be quite onerous, particularly when it's been cost budgeted and no one's taken any action. So as I say, it's certainly better to apply if there has been a significant development, and it goes back to the fundamental, all about really proper preparation going into the budget. It's a sort of fairly rare case where you're going to, say a court's got it wrong in terms of the budgeting. There's a line of authority that says, well, actually, on a cost budgeting exercise, costs and case management, the judge doesn't even have to give sort of really transparent reasons as such. It's just almost got to be a reference to why so much has been allowed in a particular budget. I think there was a case up in Newcastle where that was decided. So you can see the court, the jurisprudence coming from this court cases showing that the courts are sensitive to the judges who are cost budgeting and giving them the discretion that they have and utilising that discretion at the cost and case management hearing. So thank you.
What happens if you apply to vary your budget, but you settle before the hearing of that application?
I'm sorry,
Sorry, we've had an additional. Can you hear me?
I didn't quite get that. Yes.
So it's an additional question that we've just had in live. What happens if you apply to vary your budget, but you settle before the hearing of that application?
Well, the case is settled. It is a good question, because there is a thought that it's possible now to actually, under the new system 3.15a, for a court actually to ratify in hindsight what costs have been incurred. But the answer to the specific question is, once you've settled, and then you're then thrown back to saying, well, actually, Judge, if you do go to a detailed assessment on the matter, we were preparing to apply to vary the budget because of a significant development, but time's overtaken us, and therefore that sort of then is used to support your contention that there's good reason to depart from the budget. It just so happens that the case is settled. So I think that would be the answer to that to that question. That's how you would go about it. Seek to justify a good reason. I don't think courts won't entertain an application to vary a budget when it's actually been settled, because the case is done and whatever agreement's done as to who's paying the cost, be it a percentage or standard or indemnity basis or whatever, it'll be, it's over to the cost judge to carry out that assessment.
Okay,
thank you.
And then Helen, can you serve a Part 36 offer by email?
Fast answer. No, and our people know that. You all know that, don't you, folks? The issue that we've had in relation to service is the problem of using the court's power to sort of cure mistakes. It's not quite relief from sanctions in CPR3 that allows you to go, go on then. So the case that we refer to is the case where the Part 36 offer was served by a letter before proceedings had begun. So a pre-action Part 36 offer. I mean, this happens all the time, really. We have kind of we got used to serving and to not printing anything out. Nothing goes in an envelope now. It's all just PDF'd and emailed. And the problem is, though, that because it's Part 36, it is another document, and it therefore does need to be served in accordance with CPR 6. So having sort of sent them that and then wanting to use it, the court then did say, well, it's okay, you can do it by the skin of your teeth, and they allowed CPR3 to sort of curb the mistake. I think the problem is that it's, well, you've seen it, you've had it, I've sent you the letter, we've worked on it, I now want to bob up at the end of the proceedings and just say, wave it around and say, can I use it? And it's this estoppel. We've seen this in other cases as well, Part 36, where you sort of just work with the error somehow and nobody mentions it. And I always feel like it's sort of like the wedding service, speak now or forever hold your peace. So if you don't sort of mention, look, in WP STC, you've sent me a Part 36 by email. A, we don't accept email by service, so it's not been properly served. And B, I haven't had a hard copy in the post, If you don't say something like that, then you really are allowing people to use CPR3. And there are various subsections of CPR3 that you can use to say, well, the court can make any other order. The court can just acknowledge that a mistake has been made technically under CPR6, which is the service provision. But, well, we'll all get on with it, and I think they should have the benefit of their Part 36 offer it shouldn't be disallowed for service. But it is difficult, isn't it? Because, I mean, things have totally changed, haven't they, really? And particularly since over the last 2 years, we don't put things in the post as much as we used to. I mean, for sensible hygiene reasons, really, in the middle of the epidemic. And now just because we're all pretty lazy, I think that's the answer, really. But technically, yeah, you can't serve a Part 36 offer by email. And by that, I mean, you're sort of putting an email which says, please see attached letter. And there's a proper letter, a proper PDF attached to your email. But that's still not enough. And one of the first things I always do when somebody comes in is, before they've even got their feet under the table on the other side, is to say, can we accept service reciprocally by email? Because I don't want to have to go into chambers just to kind of pick something up or not. So, and I think most people are the same. We're all working from home. We don't really want to have it a day later when, you know, the people back at the camp have then sent it out to us. So, you know, it's often a good idea to accept service by email, but other people may feel that it isn't, that it's not your firm's policy, that you don't think it's a good idea to do that. But if that's the case and you haven't sought service by email, then although they got away with it in the case that we went through in the webinar, it's not good practice, really. So you have to kind of be aware of that. But CPR3 is there's a very forgiving part of CPR3. It just allows the court to say, oh, come on, you know, we'll sort out any mistake and we'll make an order that allows the proceedings to kind of carry on regardless. But it does need some thinking about, doesn't it? Your policy about service by email. And I wonder what yours is on that. Do you acknowledge that it's probably not a good idea and therefore you have to go in and collect the document, or do you allow for people to do that so that you get instant access to the correct version of that document, the served version of that document? It's up to you, really, what you feel is best accommodates your way of working these days.
Okay, thank you very much for that. And then, Andrew, what impact should hourly rates have on a budget, on an individual's, councils, and the expert?
Yeah, sure. I think, and the answer is none. Bluntly, the practice direction in relation to cost budgeting specifically says that any court carrying out a costs budget exercise should disregard the hourly rates. They should just reach a particular figure for a particular phase, whatever that amount is considered by the judge to be a proportionate amount. And the part of the reasoning for the question is that regrettably sometimes judges go along this route of commenting adversely about hourly rates or the grade of fee earner who's carrying out a case. Why should it be done in a City of London practice, by way of example? And the answer is that no matter who's doing the work, no matter where it is, there's got to be a proportionate cost for that case that's in front of the court on that particular day. And that's not just client's the solicitor hourly rate, it's also the expert that you use. You've got to factor in whether a court's going to approve a particular expert. So if you've got a modest multi-track, you wouldn't necessarily be wanting to go to, one of England and Wales's, top 3 experts on a particular case. There's just not the money in the case. There may be the complexity, of course, that's another feature, but assuming it's not particularly complex. And this is where I keep harping on really about preparation, because you might have a client who's got very, very deep pockets. They may wish to use one of the top 3 experts in the country for their claim that's worth £100,000. Well, that's fine and dandy. let them do so, providing you've advised them to begin with, well, actually, you're not going to recover these costs from this expert, because a judge may well consider the amount of the expert fees to be disproportionate to the complexity and value in the case. Similarly with counsel. I just choose a barrister. Lord Panic, it will not be a cheap option. Yes, you might get Lord Panic on your £200,000 multi-track if you're prepared to pay. But one thing's for sure, that money is not going to be recovered from your opponent in a case of that nature. So these are factors that you have to bear in mind going into a case, where you feel that costs are escalating. Choose counsel wisely. If you like the concept of proportionate counsel, proportionate expert, if your client wants to, go that extra mile and instruct someone more senior or more expert in a field, just to praise them of the fact that it's highly unlikely all those costs are coming back to them. They can then make an informed choice, I'm suggesting. But again, going back to the question itself, a court shouldn't bear these hourly rates in mind, which brings me to the final point about it. If a district judge does, or master starts going down that route, you've respectfully got to bring them back from it, because they're going down the wrong avenue in relation to cost budgeting, and you've got to refer them to the practice direction and say, with respect, a court at this juncture is not considering the hourly rates. It's just considering the actual amounts that are to be incurred, and that sometimes means getting a figure as a total figure and then just chopping it up into chunks to reflect the various phases that are being carried out. And I think that's really the guidance that's given now to judges, namely, have a figure in mind. It's not going to necessarily be one figure. There may be a corridor that's considered proportionate provisionally going in to a cost and case management hearing, and then, as it were, put those numbers in to try and possible reach that figure. Of course, parties may be able to persuade the judge that the case is worth more in terms of cost, because it may be a little more complex than is actually perceived by the judge going into the case. And again, this is all about preparation, isn't it? About the judge maybe have half an hour to read what you've put in front of them, maybe less. Go in there and persuade them that it's complex. So thank you for that.
That's all right. No, thank you very much. And Helen, which applications can be dealt with without a hearing?
Oh yes, this is the ticking of the box. I should just say that in relation to the last question, which I see we're on the Part 36 webinar. It's a very small slide. It was London Trocadero and Picture House Cinemas, and it's CPR 3.10, which is the quality of mercy, really, that you want when you're talking to the court. Okay, yeah. Now I like this, because I always try to find things that are sort of relevant to what we do every day. But what I quite liked about this case was that it was a kind of a how not to make an application, really. And there were lots of things that we all do in it that the court took against. And one of the things that they took against was ticking the box to say without a hearing. And there was a whole, rant really about you don't tick the box to say without a hearing unless there is agreement, basically, or it's so obvious, or it's just a very small sort of step that has to be made that we can all do it without worrying about the other side. Those aren't going to be many cases, and this was a full-blown application where everybody was against each other. So yeah, you can't tick the box, can you? Which says without a hearing, and it is a pain. I've been on the phone to people trying to list things, and well, if you can do it in 45 minutes, we can get you on in the next sort of 2 months. But if it goes up to an hour, oh golly. And the temptation is that if I can just tick that box, I can get it done really quickly. No, if there's any sign of opposition, step away from the without hearing box. And quite a bit of a rant. Also in that case as well, they waited to serve their evidence in rebuttal 3 days before the application. Now, that's okay. You can serve evidence 3 days before the application. In most applications, there are some that have a different timetable. But normally, for your average, you go first into the bat, they respond, and then the rebuttal evidence comes, and it's all done 3 days before the hearing. And that was picked up by the court. They said, well, you waited. Because often what happens is that we provide copies of the application. It's not been issued. In fact, I very rarely get back issued applications. Perhaps that's just me. But, you send it off. The other side then reply before it's been issued. Then it's issued and you get, a time hence. And then you wait until 3 days before and land your rebuttal evidence on the other side. And the court picked that up as well. And they said, look, you must have known. Because you've exchanged evidence, 6 months ago, then you get your issue and your hearing, notice of the hearing date, and you wait till 3 days before I know what the rules say, but it's ambush. And so everything's relative, isn't it? If you're doing something along the corridor in the High Court where it's kind of on the hoof or whatever, fine. But if you've got that gap, you're supposed to be exchanging evidence proportionate to that gap. Don't leave it to the last minute.
Thank you very much. And back to yourself, Andrew. Are the courts still bending over backwards to assist LIPs?
Yeah, the reason this is on here, I think, is that many practitioners perhaps reasonably think, oh, well, the courts have always got it in for solicitors and counsel. They always make the lawyers apply the rules religiously, zealously. But when it comes to litigants in person, it's a completely different kettle of fish that the courts will bend over backwards to them. And that, I've heard that any number of times. The answer is actually a little more complex. First of all, with regard to litigants in person, generally they're not legally trained. And therefore you may get a judge who exercises more patience towards the litigant in person because they're wanting, they know they're not legally trained and therefore will talk at length about irrelevancies, and the judge is hopefully trained to be at least well-mannered when dealing with matters. And I know people say, oh, well, most of the judges I come across are not, they'll just cut you off at the knees. But there's got to be a degree of common sense about this. So first of all, LIPs are generally not legally trained. A judge's role really primarily is to remain impartial in relation to a case. That's the job. So what you'll find with judges, they should be jogging litigants in person along, or indeed those who are legally represented. If they've made a point twice, you don't need to make it 3 times. And so you get them to move on, by, using terminology such as, I have that point, I'll deal with him in my judgment, and the like. The other thing that I wanted to bring to people's attention is really to sort of debunk the myth that there are thousands of litigants in person out there who are unhinged, if we can call it that, in a polite way. I know some practitioners, including myself, will perhaps give an adjective that's a little more disrespectful. But interestingly, and these are rhetorical questions, so I'll give you the answers. How many civil restraint orders are presently in place in England and Wales? The answer is just about over 100. and in relation to extended civil restraint orders as we speak, it's just over 200. So this idea that, yes, of course there are unhinged litigants in person making multiple applications and suing the same people over and over again, but the idea that they're in there thousands and thousands is actually a bit of a misconception. And the court, I can assure you, judges are now a lot more alive to pushing matters to civil restraint, whereby you are certifying, for instance, an application has been made totally without merit, and then that can lead to a civil restraint order being made by the appropriate judge. So there is the mechanism to do that. A second feature of LIPs is the case which is was in the webinar, which is Ray versus Ray, where the Court of Appeal actually chastised a master for cutting short a litigant in person, where the litigant in person wasn't allowed to cross-examine properly the opponent. And the rationale behind the master cutting across was they didn't have the skill set to cross-examine, so I'm not allowing them to cross-examine, which rather defeated the object of the adversarial system that we still are involved in. And the Court of Appeal said, well, we can understand why that happened, but it's not a good reason to cut someone short. And again, this is it becomes more of a judge problem and a hearing of getting people to focus on the real issues, the real topics, where perhaps they've a litigant in person has got an agenda to run, has become slightly unhinged by the process, feeling anxious, fraught by going into a hearing, and actually is coming at a case in a misconceived way. But they're not getting the legal advice to say, well, actually, that point's a bad point. It might be what they think is a really strong point. The danger for the system is, in fact, where a litigant in person has got a good point to make, but it might be the fifth point that they want to make. And so a judge, as I say, has got this like jog on approach. Let's move on. But the Court of Appeal has said you shouldn't cut across and prevent cross-examination. Probably the better policy is to articulate the scrutiny through the judge. So if a litigant in person wants to ask cross-examination questions, maybe get the judge to involve themselves. The Court of Appeal said a judge is not there to cross-examine. Actually, in my experience, and I'm not trying to disagree with the Court of Appeal when I say this, but in my experience, overwhelmingly, a witness in a witness box would rather be questioned by a judge than a litigant in person. And so what I do, sitting, and I may be wrong, is ask the litigant in person what are they getting at? You know, what do they want to actually put to this witness? And that includes, in my experience, putting to a witness that they were racist. You know, that it was part of the case, and this litigant in person said, I've been discriminated, etc., because of my race. And I put that question to a housing officer. I wasn't cross-examining because I got the litigant in person actually said, this is what I want to ask. This is a litigant in person with, you know, mental health issues and the like. And that worked in my experience quite well. And so the rationale is get the judge involved to sort of prevent matters escalating out of control and it becoming quite unseemly. And that's the job of the judge, you know, but fundamentally, a judge has to remain impartial in a case. You know, judges can't be thinking up questions to cross-examine, to assist a litigant in person in that way, because that is not fair to the other party who may be legally represented. So I think that deals with that question, hopefully. Thank you.
Yeah, no, thank you very much. And Alan, can you explain the discretion point in the security for costs case?
Sure, yes. And just before I do, I just want to say, gosh, Andrew, you're a very nice judge to have. So, I think I agree with you just on the last point, because they are a nuisance. I haven't done one for ages now, litigant person, but I went through a phase of, having to be against them, and just bearing the frustration of the client, really, who had to prepare the bundle. And, the court would just say, well, you've got to help the whole process along. But I think what often I've seen judges do is just take the pleadings that the litigant in person has put into court and try and help them to put their case through the pleadings. But I agree with you, they can't stray off and conjure questions, which but of course the judge can ask any question they want, not necessarily related to the litigant in person. They can just say, well, can you help me with, I want to know that, and that may be quite closely allied to what the litigant person is trying to say, but they can't actually manage to articulate it. So but it sounds like Andrew's a very nice judge to have if you've got the bewildered or just the rest of us, really.
Sure. I mean, to feed off that, the racist question, I suspect the litigant in person was never going to put that question to that witness. He just perceived that it's out there. This witness is racist. He wouldn't even clock it that I need to ask the question to get him to deny it, as it were. So, but anyway, sorry, I interrupted.
No. I think they are. It's difficult to manage, isn't it? But but the rules are. I mean, we had the Wright Hassel case, didn't we, on service, where the court made a really strong pronouncement that, I mean, this is what I was saying with email. He used email and didn't understand that he had to serve the particulars of claim, wasn't it, in that case? And the court said, no, you don't get a by here. You don't get a way around it. It's 3.10 or not, You have to comply with the rules. And the Wright Hassel case is always the one, Barton, isn't it, Mr. Barton? That I use in that situation to say, look, it has to be a level playing field, and we extend as much mercy as we can, but basically you have to come in and make a finding that's correct with the rules. So, anyway, sorry, I digress. Yes, security. Oh, I was so cross about this. I had a really good application for security for costs, and I've always won applications for security for costs as a defendant against a claimant, where you can show that the claimant is broke or abroad, basically. Or nominal. I've had one where they were nominal; they were just fronting a case, and I lost an application, and I was really disgruntled about this because the claimant didn't have any money. It was beyond any reasonable doubt, really, because all the company books could show that. We managed to get all sorts of evidence, put it in a witness statement, and then promptly lost the application. And possibly we should have appealed. I don't know. But the reason that I've included the Heathfield case and we're back on the update now, aren't we? So I should say that one about ticking the box is the Taylor-Wimpey case. That was the pre-action disclosure case. The Taylor-Wimpey case was the one about ticking the box. But now we're back on to the update, and it's the Heathfield case, which is at slide 28. Heathfield International and Axiom Stone 2021 Court of Appeal case on security for costs. Yeah, and it's the discretion, and you forget that no matter if you trip the threshold in CPR 25.13, you still have to get, and CPR 25.12, you still have to get through CPR 25.13(1)(a), which says it's only going to make an order for security if the court is satisfied that it was just to do so, having regard to the circumstances of the case. And in this case, it was they're suing a firm for unpaid invoices from an agency. I think it's an experts agency, but there was some sort of hanky-panky involving the defendant and forged invoices, and the court just thought, well, it gives you such a powerful step, isn't it, getting security for costs if you're a defendant, and the court don't make the order for security for costs. And pretty much my case, he said, why not? It's really clear on the figures. Yeah, but there's other situations here that we're not so sure about. For example, there's an allegation that there's been a forgery of the signature. We haven't quite got the right documents that led to the contract, that led to the invoices. And there's just basically a bad smell about this case. So on a discretionary only basis, which is how I lost my application, we draw back from making that order. And, I think that it is well to remember that you make these applications and, it can look very strong. And it is a very powerful position. If I've got a defendant with half a chance of that, I'm normally very keen that we make that application. So it puts you in a much better position tactically. But you can have all those threshold criteria ticked and they can still draw back. It's almost a sort of clean hands point, isn't it? I'm coming and there's nothing untoward. There's no other reason to stop that. But in my case, I've often thought maybe we should have appealed because the use of that discretion was not quite, clear here. That they could see that that there was something to pin it on, some facts that affected the cleanliness of the hands, if you like. I'm mixing my metaphors there because it's not an equitable test, but there's some other circumstance that prevented the application from succeeding. So it just rang a bit of a bell, really, with me.
Okay, thank you very much for that. Is there anything else you'd like to add, Andrew, just before we wrap up, because we're just unfortunately running out of time? You're on mute, sorry.
Yeah, no, there's nothing I'd like to add at all. Thank you.
Okay, well, thank you ever so much, Helen and Andrew. Unfortunately, that's all that we've got time for today. So thank you for attending LAW2022 Online, Civil Litigation Spring Shape the Debate, and obviously to our experts for attending and answering the questions. And as mentioned, this recording will be available on the website in the next couple of days. It's www.thesolicitorsgroup.co.uk. And if you've purchased the online course, there's still time to watch all the pre-recorded content and all the webinars that Helen and Andrew have referred to through the Q&A session today. The expiry date is displayed next to your webinar. And if you've not, then you've still got time that you'll be able to buy this event, including the recording of this live session as well on the Solicitors Group website. And also, finally, you will find your feedback form for the course in the related links section. And once you've completed that, you will then receive your CPD certificate via email for the webinar session. So that's everything from myself today, and we'd just like to thank you again for attending and have a great day.
Thank you.
It's okay.
Bye-bye.
Okay, bye.
Bye-bye. Bye.